So enforcement, I'm going to talk about just for a little bit. A claimant under Chapter 56 must enforce the lien within the same time and in the same manner as a mechanic and materialman's lien under Chapter 53. So this is kind of how they kind of become interconnected. And that enforcement, those enforcement limitations are right here on my slide. And this is for both M&M and mineral liens. So for commercial property, it's within 2 years after the last day the claimant could have filed the lien affidavit, or which within 1 year after completion, termination, or abandonment of the work under the original contract. And it's whichever is later. And clearly that's the one we're going to use for the mineral liens under Chapter 56 because they're not residential. And then for the residential properties under 53, it's 1 year after the last day the claimant could have filed the lien, or within 1 year after completion. So you have less time if you are working on a residential property. Just keep that in mind. Okay, I really want to go over this just a little bit because this is probably, the whole reason that we're here. We have a valid lien, so now what do we do with it? Well, a lot of the times, just the threat of foreclosure is really enough to get us what we want, which is to get paid and get our clients, out of here. We don't want to be involved in any more litigation if possible. And this really works a lot of the time. The lien, if filed properly, is now an encumbrance of it's now an encumbrance on the property. It puts unwanted attention on the project. And like we were kind of talking about a little bit before, it does trap funds from the owner. So, when these notices are sent and the liens are filed, the owner is put on notice and gets very nervous about paying the GC. And it just kind of disrupts the whole process of the project, which we want to do, because if we're not getting paid and they're not answering our calls, there really isn't much else for us to do. And so, like I said here, it can result in a lot of deals being made. We can do payments, we can do settlement agreements, sometimes promissory notes. And I did want to mention here, especially for mineral liens, in some jurisdictions, just having the lien filed is enough to be able to trap proceeds in production. We can't do that in Texas, but this is something that we keep running into at our practice in the other jurisdictions that we work in, namely Wyoming and Oklahoma and North Dakota. Another part of the property that you get a lien in is actually the production. You don't get that in Texas, but other jurisdictions you do. And with the lien, you can actually trap funds with the purchaser of the production. So not the owner, but the person who's actually going out and purchasing the production for sale or distribution. So that's all what we can do with the threat of foreclosure. We don't have to actually even go foreclose. We don't have to even file a suit. We just have the lien in hand and we can go do something with it. Now, we can also, of course, actually foreclose. We can sell the property in order to pay for services and labor and materials. And in that case, all lien claimants will share pro rata, subject to priority. And this is kind of the nuclear option. I think everyone always knows, having to actually go foreclose the property is, pretty big deal. And we don't normally have to get that far, but if it's necessary, then our lien gives us that right and that opportunity if we want to. I do want to talk just a tiny little bit about bankruptcy. Our firm does a lot of creditor work in bankruptcies where we've got liens and we're representing creditors. And so a question that comes up a lot to us is if a lien can be filed, if their customer has filed for bankruptcy. Can we file our lien if a customer has filed for bankruptcy, and does it violate the automatic stay? And so the answer to that is we can file our lien and it does not violate the automatic stay. And so and that we very, very highly encourage everybody to make sure to get their liens filed if a customer has filed bankruptcy, because this is going to be the difference between having an unsecured and a secured claim in a bankruptcy. And if you know anything about bankruptcy law, you know that unsecureds are at the very, very bottom of the payment priority list, and they are not going to be getting very much. And so the higher up you can get on that list of getting paid, the better. I did mention priority here, but I'm not going to go into it too much. It can get very lengthy. Of course, this is all subject to priority. There could possibly be a mortgage in front of the lien, and we'll have to deal with that, on a case-by-case basis.